tuning in today. Really appreciate you all signing up and logging on. Just let me know that you can hear me okay. If you just want to type into the chat box that you can hear me, that would be really appreciated. And if it does cut out at any point, just keep on typing in the chat box, and then Liz can see that and we can help to sort it out. A few of you are typing in to say that you can hear, so that's perfect. Thanks ever so much. So the purpose of today's webinar, we're going to look at dealing with large-scale redundancies. So previously, I have done a webinar on sort of smaller scale redundancies, and I did that in December, and that has been recorded, so you will be able to obtain that if you want to listen to that also. And then myself and Marie did a Q&A in January, but that wasn't recorded. So we have looked at redundancy in the past, but arising out of our previous webinars, I think there was a real need or a request really to look at collective redundancy consultation in more detail. So today we're going to look at the process of what happens when you are planning to make redundant 20 or more employees within a 90-day or less period at one establishment. So as I just previously mentioned before, for smaller scale redundancies, this is where there's fewer than 20 employees. The collective consultation process doesn't apply, but you still need to make sure that you carry out a fair and reasonable process. And for more information on that, you can listen to the other webinar that I ran in December. As Liz said also, there is a chat box there, so if you have any questions during this webinar, please feel free to use it, and I'll pick them up as and when I can. I might stop every now and again to deal with some questions in between slides, so please feel free to ask away and just use that chat box to put forward your thoughts, or if you want to put forward any other discussions. Before I sort of get into the nitty-gritty, Liz has done a poll for us. I think she might put that up there now for us to see basically if anyone is currently undertaking collective redundancy consultations. If you just want to fill in that poll, that'd be really good, just to get an idea really, to see if any of you are undertaking it. I think at the moment about half of you are saying not at the moment, but you're interested to understand a bit more, and then some of you, about 15%, are currently undertaking one, and about 45% is planned. So that's quite interesting to know. So thanks ever so much for that. Right then, so moving on. That poll's still up on my, there we go, it's gone now. Thank you, Liz. Right, so first of all, we've just got a disclaimer that Liz puts up for me, just to obviously set out that it's not particularly legal advice. I'm not dealing with individual cases, but it's just a general discussion on the area on collective redundancy consultation. So today we're going to have a look through what is collective redundancy consultation, go through an overview of the process and perhaps some key points that you need to have a look at. And I know somebody pre-webinar asked if there was a checklist to approach the topic, and perhaps the overview that I go through might work as a checklist for you, and so that might be useful for that. Relationship between collective and individual consultation. I know pre-webinar somebody asked, do we still need to hold individual consultation meetings as well as collective consultation? And yes, you do. That still is required. When can you dismiss? And then rights of redress for employees. So first of all, just thought it'd be interesting for you to understand where the legislation sits. So we've got this Trade Union Labour Relations Act, which implements the European Collective Redundancy Directive. So it's section 188 of that legislation that you need to consider when you're looking at collective consultation. And also ACAS have helpfully issued a guide. I mean, ACAS have been quite busy at the moment and issuing guides left, right and centre on everything, which is really helpful. So there is a guide by ACAS on large-scale redundancies, which could also prove useful. And for the person who asked about the checklist, I think within that guide there's a flow chart as well. So that might be a useful mechanism just to print out and have on your wall, just as a flow chart to understand how the process starts and when you've got to consider things. Okay then, so moving on with the webinar. What is collective consultation then? So before we get into looking at this process, it's perhaps useful to remind ourselves of what a redundancy is. So we find the definition for redundancy in section 139 of the Employment Rights Act 1996. And broadly speaking, we've got things like business closure, workplace closure, or reduction of workforce, so where there's a reduced requirement for employees to do work of a particular kind. Redundancies themselves commonly arise when an employer normally needs to close or move part or all of its business, make cost savings due to loss of orders, changing customers' demands or an efficiency drive, or where there could be new technology introduced or a reorganisation of the way the business is run. So it's quite useful to understand what the redundancy definition is, because there needs to be the genuine redundancy scenario to then kickstart the next element of the process. So what is collective consultation then? So we'll look at this in a little bit more detail now. So once you've established that there's a genuine redundancy scenario, the next area to then have a think about is how many employees will be impacted by this, because depending on the number of employees impacted will determine whether we need to look at collective consultation or whether actually we can forego the collective consultation because there's not enough employees impacted by it. So if an employer is proposing to make redundant 20 or more employees at one establishment within 90 days or less, collective consultation applies. So this is the key really. So once you get to the level of 20 or more, this is where you need to start looking at collective consultation. So the law defines collective consultation as a dismissal for a reason not related to the individual concerned. So if the dismissal is related to the individual concerned, that will be things like relating to their conduct, their performance, and that's a different type of dismissal. So it's got to be a dismissal that's not connected to that individual concerns. It's got to be things like a redundancy, and it's got to be a genuine redundancy scenario. And I've put on there a note to say, if you're considering changing the contract of 20 or more employees, and this will also, really fit within the definition of collective consultation. So this might include a dismissal process where you will need to collectively consult. So if you wish to change the contract of 20 employees or more, and if you do as part of that process decide to terminate those individuals and issue new ones, because you are dismissing them and it will be classed as a redundancy type scenario for the purposes of the collective consultation legislation, it will trigger the statutory right to collectively consult. So that's something to also bear in mind as well. Just like a note really for you when you're looking at that. So first of all, you look at your definition of redundancy, then you consider how many people are being made or potentially at risk of redundancy to determine whether it's collective consultation. And really, what is collective consultation? So the law states, so we go back to the legislation, that when proposing to make redundant 20 or more employees at one establishment within 90 days, an employer must consult with any recognised trade union, or if there isn't a recognised trade union, with any other elected employee representative, must start consultation in good time, so this is at least 30 or 45 days before the first dismissal takes effect, depending on the number of proposed redundancies. No dismissals can take effect until consultation is complete and the minimum of 30 or 45 days has elapsed. We must consult on ways of avoiding dismissals, reducing the numbers to be redundant and mitigating the effects of the dismissals. Must also disclose in writing to the appropriate representative certain information concerning the proposed dismissals and notify the Secretary of State at least 30 or 45 days in advance using a form HR1. So you notify them in advance of the first dismissal taking effect. So that's just an overview, a very brief overview of what collective consultation and what the law sets out. I mean, it's just important really to note for yourselves as a business why consultation is so important. I mean, really, in reality, the reason why this sort of legislation is in place and why it's driven as a mechanism going forward is consultation does really allow you good communication with your staff who may be impacted by your redundancies. And really by communicating, consulting with them and giving the representatives the information that they require should hopefully allow you to enter into effective consultation and also understand their views, listen to your employees and their views on suggested ways forward. And it may actually turn the redundancy on its head. There may be some other solutions that could be reached, but also it might help to keep your employees engaged as well, because it's a turbulent time as redundancy, and if people feel that they're genuinely being consulted with, then they may feel a bit more engaged, and also it may help the business to survive the redundancy process going forward as well. So that's just a commercial sort of outlook really on why consultation is important and why this is sort of dealt with under the legislation. So what we're going to do next, we've sort of covered off those points there on that slide about what collective consultation is. I'm going to look at the process in a bit more detail now. So I'm going to do like an overview and key points. Before I move on to that, does anybody have any questions they want me to answer now? I mean, I might answer some of your questions throughout the overview process, but if anybody has any burning questions right now, I'm happy to answer them. I don't think anybody has yet, but like I say, just keep typing away if you do have any questions in the chat box. So, overview and key points then. So, first of all, when does your consultation start? So, consultation under the legislation must start in good time, and it must begin at least 30 days before the first dismissal takes effect if 20 to 99 employees are to be made redundant at one establishment over a period of 90 days or less. So that's the first one. And then the second one, at least 45 days before the first dismissal takes effect if 100 or more employees are to be made redundant at one establishment over a period of 90 days or less. So employers must start the consultation process early enough for meaningful consultation to take place. I mean, in reality, presenting a proposal as a done deal will not allow employee representatives the chance to play a constructive part in discussions on the possible way forward. So it's got to be a meaningful consultation. In terms of the consultation process, it is a bit of a common misconception that the collective consultation must last for the relevant minimum periods that state on this slide. In reality, and in fact, the requirement is for that minimum period to elapse between the start of the consultation and the date the first dismissal takes effect, not for the duration of the consultation. In reality, many employers actually deal with consultation and use the 30 days or the 45 days as the period for the consultation, and that is quite a prudent approach because then at least there's a fair time frame. But strictly speaking, the legislation just determines when consultation must start, and in fact actually that minimum time period goes towards the time that must elapse between the start of the consultation and when the first dismissal takes effect. Hi Shireen, you just asked, when do you need to contact the Secretary of State? Yeah, you need to contact the Secretary of State 30 or 45 days in advance of the first dismissal taking effect. So it's 30 days if it's 20 to 99 employees and 45 days if 100 or more employees. So you contact them before the first dismissal taking effect. So that's the first thing to consider. When does consultation start? To consider the number of employees to be made redundant, and that will determine the minimum minimum period of when it must start. The next thing to consider is what is meant by an establishment. Now, there's been a lot of discussion over this recently because of the Woolworths case. In reality, what's now arisen out of the Woolworths case is that in order for the legal requirement to consult to take effect, an employer must propose to make 20 or more employees at one establishment redundant. So the European Court of Justice, and this is following the Woolworths case, has said that establishment means, depending on the circumstances, the unit to which the workers made redundant are assigned to carry out their duties. So thankfully in the Woolworths case, which went all the way to the European Court of Justice, the ECJ, they decided that the requirement for collective consultation is triggered when employers propose 20 or more redundancies within 90 days at one establishment and not across the entire undertaking. So we're back to looking at the one establishment, and I've put on that slide some points that may help you determine if it's one establishment or not. So is it a distinct entity? Does it have a degree of permanence and stability? Does it have the ability to carry out the tasks it has been assigned? Does it have a workforce, technical means and organisational structure that allows it to carry out its function? So that's something to consider, and obviously there may be issues involved when you're looking at employees that may be a bit more mobile within the workforce, and you may have to look at the contract to determine where the place of work is and actually look into that a bit more detail. But we are back to the point where it's one establishment that is the key really now.
Can I just mute the line, Caroline, before we go
yes,
further?
Can,
a little bit of interference there, so just bear with me, everybody. Okay. There you go, Caroline.
Thank you. So looking at the how many employees are involved point and just picking up on that, I think it's useful to understand other points on this area, because often you may think, oh, there's only 17 employees being made redundant, but you might have accepted some voluntary redundancies, and voluntary redundancies are included in the total. So for example, if you propose to make redundant 22 employees, but 6 of those volunteer for redundancy, then you still have to go through the collective consultation process. Shirley's just asked a question. So these slides refer to employees being made redundant and not the roles. I mean, in reality, Shirley, in redundancies, obviously it's the role that's redundant. I mean, when we're talking about a number of employees, we're looking at who might be impacted by the redundancies. So if as a business you have to reduce your sales workforce by, so you've got 60 sales managers and you have to reduce them, and you can only got work for 30. So it's 30 people that may be at risk of redundancy. It's a 30 job roles of the sales workforce that we're looking at. It's just the sort of terminology may interchange between each other when you are looking at that. So yes, the voluntary redundancies are included in the total. Redeployment will count towards the total number of the proposed dismissals. So if an employer proposes to make 17 employees redundant and redeploy a further 5, the total number is over the 20, so collective consultation must follow through. So these are just some points to be aware of when you're looking at the total number of employees and calculating whether collective redundancy kicks in. On fixed-term contracts, and we did have a question about this pre-webinar, so hopefully I'll have covered this off in answering this now, but if I haven't, please let me know. With fixed-term contracts, it is a bit of an anomaly. So if you've got an employees on fixed-term contracts which are going to come to an end at the end of the agreed duration of the fixed-term contract, they naturally come into an end on the date they're meant to come to an end, and that's fine. Those employees will not be included in the calculation for collective redundancy consultation purposes. However, if the employer, or if you as a business, is proposing to dismiss the fixed-term employees earlier than the date agreed, and the reason is redundancy, then you will have to include those fixed-term contracts in the count for collective redundancies. So that is something to be aware of in fixed-term contracts. If you do have any employees on fixed terms, consider when they are coming to an end, and is it by virtue of the fixed-term contract, is it as agreed under that? And if it's not, and if it's due to redundancy, or if it's coming to an end earlier, then you will have to include them in the in the collective redundancies consultation process. And then Heather just asked a question. If you have already made, say, 17 people redundant, but then have to do a second round of redundancies, to avoid collective redundancy, does there just need to be a 90-day gap between the start of the first redundancies? This is quite a good question, actually, Heather, because if collective consultation has already started on a separate redundancy situation within the same organisation, so the dismissals which are already subject to consultation do not have to be taken into account when considering a new proposal to make employees redundant. So say, for instance, you propose to make 30 redundancies and you begin collective consultation on those 30 redundancies, and that's going ahead. Then the business proposes to make another 10 redundancies within the same overall period of 90 days. Because consultation has already begun on the original 30 redundancies, the subsequent 10 redundancies can be viewed in isolation, and there'll be no obligation to consult about them, under the collective consultation process. However, if the collective consultation process hasn't started at all, then you'll have to collectively consult with all of them. So it's a bit of a strange one, is that. However, there is sort of guidance in the legislation to say that we shouldn't deliberately stagger redundancies, to get around collective consultations. We shouldn't start consulting with 30 and then stagger and then do 10 later on just to get around collective consultations. If there's a genuine reason why 30 started at one point and then actually there's a second round later on, you may be able to fall outside of it. Also, Heather, saying if you've already made 17 people redundant and have to do a second round of redundancies to avoid the collective redundancy. Perhaps, yes, if you've done 17 redundant and there's another within the 90 days, I mean, if those people, it's a bit of a tricky one, because if those people have already been made redundant, if it's 17 people and they've been made redundant because the process isn't the same as a collective redundancy, then the next ones, you may have to follow through on collective consultations. It might be better to wait for the 90-day gap. It'd be something you'll have to have a consideration about, actually, and have a think about in more detail for you. Anyway, I'll just carry on for now, because I'm conscious of this time and I don't want us to run over. Right, so moving on to further overview and key points. So who to consult? So when you're looking at collective consultation, employers must consult with representatives of any recognised independent trade union or other elected employees representatives, if no recognised trade union. So employee representatives may be elected solely for the purposes of consultation, or may already be some in place, and the statutory rules set out in the legislation about how to elect employee representatives. So if there isn't a recognised trade union, then there's elected representatives for the employees. And then information to be disclosed then. So as part of the collective consultation process, employers must disclose in writing to the appropriate representatives the following information concerning proposals for redundancies, so that they can all play a part in the consultation process, really. So I've set out on that slide what information should be disclosed. We've got to set out the reasons for the proposals, and the numbers and descriptions of employees, the numbers and descriptions of employees it proposes to dismiss as redundant, the total number of employees of any such description employed at the establishment in question, the way in which employees will be selected for redundancy, so looking at the selection criteria that we'll be considering using, so that being objective, how the dismissals are to be carried out, taking into account any agreed procedure, including the period over which dismissals are to take effect, the method of calculating the amount of redundancy payments to be made for those who are dismissed, and agency workers. We now have to include the number of agency workers, where they are working and type of work doing. And we have to include this really meant to be as a benefit for agency workers, but I'm not really sure if this makes them more vulnerable, because what you might find as part of the process is representatives will ask for the employer to stop using or to reduce the amount of agency workers if that will reduce redundancies going forward. So all this information has to be included and sent out to the representatives for consultation. And then really this next slide is key, because consultation itself should be genuine and must be undertaken by the employer with a view to reach an agreement with appropriate representatives on these issues. It's on these issues that I put on this slide. So consultation must be undertaken to include ways of avoiding the dismissals, reducing the number of employees to be dismissed, and mitigating the effects of dismissals. So that's how consultation is meant to be seen. That's the full purpose of it, for it to be genuine, undertaken with a view to reach an agreement on these points. And that's why really it should be carried out in good time, with enough time for it to be genuinely carried out, and for all the information to be given so that each party can play their role in trying to come to some sort of other solution with it. It may be the case it's not always possible for consultation to find ways of avoiding dismissals. It may be that just can't happen. But at least genuine consultations about the business reasons behind the proposals are more likely to produce some creative solutions, or at least people feel that they're being informed, and it may sort of redress that balance as well. Vicky, I'll just stop there because Vicky's asked me a question. If we don't know how many people will be made redundant because the part-time and full-time workers will be affected, but those made redundant after selection process could be more or less than 20, should collective consultation still be followed? It may result in more than 20 redundancies. Yes, I would definitely say, Vicky, I think if you're not sure and it could be over 20, just to play on the safe side and to avoid any dispute going forward or any risk, you're always better off to play with caution and go follow the collective consultation process through, because you'll never be criticised for doing that, whereas you'll be criticised if you didn't follow it through and it actually resulted in more. So that's what I would do. And then in relation to how long should consultation last, I mean, as I said previously on one of my other slides, the law states when consultation must start. So we had back previously, it must start at least 30 days before the first dismissal takes effect if 20 to 99 employees are to be made redundant at one establishment over a period of 90 days or less, or at least 45 days if it's more than 100 employees. So the law states when consultation must start, but it doesn't state how long it must last. I mean, like I said previously, employers tend to use a 30-day and 45-day as a guidance anyway and carry it out for that period. But it can go beyond that. It may be a little bit less. But what you have to understand is that consultation must be carried out with a view to reaching an agreement. And once you've done that, and you've genuinely done that and tried to, consult on these points on this slide, then really, you can bring it to an end once genuine consultation is being carried out. And then once you've done the collective consultation process, then you'll have to obviously consider individual consultation process. So as an employer and as a business, you need to be flexible about how you arrange individual consultation. Perhaps most organisations, or indeed some organisations, will wait until collective consultation has ended before consulting individual employees who are to be at risk of redundancy following the process. But there may be situations where it's appropriate to run collective and individual consultation at the same time, so concurrently. So for instance, you may, as an employer, as a business, have come to an agreement with employee representatives on how the number of redundancies and how they will be selected, but discussions may still be ongoing about the redundancy payments themselves. So whilst still discussions are ongoing about that, it may still be worthwhile starting an individual consultation and following that process through, and then at least you're moving on with the process. I mean, in terms of individual consultation, I've just put some points really on this slide. As part of that, you would have to write to employees who've been provisionally selected, so following the selection criteria being carried out. So when you've looked at your pools of who's at risk and you've done your selection criteria, write to those who've been provisionally selected. You have individual meetings with those employees so you get their chance to put forward their other thoughts and suggestions and discuss the selection criteria and discuss scoring that's being carried out. They have the right to be accompanied, so they can bring along a trade union representative or a colleague. And it's always important, as always, in everything to do with these matters, to listen to the employees and listen to them so they feel that they're being heard. And obviously minute all your meetings so everything's documented and you've got your letters all set out as well. So individual consultation, as I said at the start, does still happen as part of collective consultation, and it is really still an important factor. Shirley's just asked a question: who decides that consultation exhausted every option? and consideration, please. I mean, really, it'll be up to the employer to decide that effective consultation has happened. I mean, in reality, what probably will happen in practice is when you are talking to the trade unions and the employee representative, you'll probably agree between yourselves that actually collective consultation is now finished, as far as it can go. You've looked at all the options, you've dealt with everything, all the information's been provided, you've consulted with a view to reach an agreement, and then you move forward into the individual. So I think it'll probably be agreed together, but ultimately it'll be for the employer to determine and decide, looking commercially, that it has been reached and has been exhausted. And then when does dismissal take effect? So redundancy notices must not be issued until collective and individual consultation has been completed. The dismissal itself cannot take effect until the minimum period has expired and individual notice periods have been observed. So it's something to bear in mind. And in terms of the notice period, if you don't have a contract in place, or if you do have contracts in place and they're lower than the statutory notice period, you've got to be aware that an employee is entitled under statutory legislation for a week's notice for each year of employment, up to a maximum of 12 weeks notice after 12 years or more service. So it may be that your contractual periods might say 4 weeks on either side, but if you've got an employee with 10 years service, they will be entitled to 10 weeks notice. So bear that in mind. And then also, if your contracts allow it, you could pay the employees in lieu of notice rather than have them work it, or pay part notice and have them work part notice. So the employment can be terminated before the end of the notice period by paying them in lieu, so by exercising any pile-on that you may have in your contract. And then really just to round off, really, just the rights of redress. So what an employee can do if they feel unhappy, with the decision or unhappy with what's happened. So if the employee concerned believes there's been a failure to collectively consult, so they don't believe that the employer has correctly carried out the collective consultation legislation requirements, so where the employer fails in any way to comply with these requirements or to consult about proposed redundancies, the complaint will be to an employment tribunal. That's the arena in which it would be dealt with. And the complaint is made by either the appropriate trade union or the elected employee representatives. They're the people who make the claim for the collective redundancy consultation breaches. But where there is no appropriate trade union or other elected employee representative, then it can be made by the employee who's been dismissed or may be dismissed. So they can make a complaint to an employment tribunal. And if the employment tribunal agrees that there has been a failure on collective consultation requirements, then what normally is awarded is this thing that's called a protective award. So they can make an award for this, and the maximum amount that could be awarded is 90 days pay. And there isn't a maximum on a week's pay, so the statutory maximum on a week's pay doesn't apply to protective award calculations. Now, a tribunal will take into account what has happened, so the length of the protective period pay or the protective award is at the employment tribunal's discretion, so they will look at what has happened. So if there has been a period of collective consultation, the employment tribunal will look at that and may reduce it accordingly. So say, for instance, it was a 30-day, say for instance the minimum time period for when consultation should have started was 30 days, and say the company did carry out 30 days consultation but part of it wasn't correct, they may limit the protective award to 30 days rather than it being a 90 days. So there is some flexibility there. So the maximum is 90 days, but the tribunal will look at what has happened. Also bear in mind as well the unfair dismissal claims. This is why individual consultation is also so important, because employees who have been dismissed and have over 2 years service for redundancy, or just 2 years service generally for unfair dismissal, but who have been dismissed for redundancy can bring an individual claim, the unfair dismissal claim. Generally the time limits are always 3 months, so for unfair dismissal 3 months from the date of dismissal, and for the collective consultation it's generally 3 months from the last dismissal. And as always, and as at the moment, employees have to use the ACAS early conciliation process to start the claim, so that stops the clock in terms of time limits, and then also they have to pay the employment tribunal fee. So I mean that's just a general overview really at the moment. I just wanted to give you an overview of the collective redundancy consultation process. You've just got something to understand and take away with you. As always, happy now to answer any questions that you may have. If you want to type into the box, or if you've got anything else you want to talk about, that's fine. I think we also like to know, don't we, Liz, of any future topics you like would like to be covered on these webinars, and we're always interested in any topics you might want us to talk about rather going forward. If you've got any suggestions for future topics, please let us know.
Absolutely, Caroline. Yeah, there's a lot of information there, Caroline. Loads, thank you. I forgot to mention as well that the slides for everybody, if they want to download them, you can see them at the downloadable docs section at the bottom of this webinar. So please feel free to download the slides from Caroline there today. Quite a few people typing at the minute, so we'll just sort of give that give the chat box time to sort of catch up with itself. But no, some very useful information. I'm sure everybody will agree to that. And lots of really good questions as well came through. So well done for sort of incorporating them in.
Yeah, really good questions. I mean, and like I said at the start as well, I mean, also remember there is the ACAS guidance. You know, if you do, because the legislation itself, I know it can be so tricky. Any employment legislation itself can be so tricky to understand. And often, like I say, the ACAS guidance can be quite useful. So if you haven't looked at it yet, or if you haven't downloaded a copy, it might be worthwhile just printing out a copy and keeping it in your desk, because that might be able to just be a quick port of call for any questions that you might have as well.
I did put the link to that as well at the beginning of this chat. So if you want to scroll up the chat box, everybody, you'll see that the link is there to get that from ACAS.
Oh, perfect.
You've got a few questions. You've got a question from Claire, so I'll let you answer these.
Thank you, Liz. Right, so Claire, thank you. If an employee is off sick, you need to take into account with time periods of consultation. If the employee is off sick and they're going to be impacted by the redundancy matter, then yes, you will need to you'll need to obviously consult with them, and they'll need to be involved as part of the process. Obviously, that's if you hit the mark of 20 or more as well, so you will need to factor that in too. Shirley, one further question, if I may. How does collective consultation work for those who are on maternity leave and have accumulated holiday time? Will this be taken into account in terms of notice period if redundancy happens? So if you've got, so say for instance you've got the employees on maternity leave and they've been impacted by the redundancies, they've been involved in the process, you know, as they should do, collectively consulted with and dealt with. If they are then terminated, then they will still be entitled to any holiday that they have accrued. So obviously the holiday entitlement carries on whilst they're on maternity leave, and they continue to accrue holiday whilst on maternity leave. So in terms of the notice period, if they effectively a working notice, and you could ask them to take any accrued holiday whilst they're on notice, because you can do that, or if you're paying them the notice, then you might have to pay them, you'll have to then pay them the accrued holiday entitlement. It depends on how the notice is being treated, and actually if they're redundant whilst they're on maternity leave, and so the notice pay actually refers to maternity leave pay. It would have to be something you'd have to have a look into at the time, but they would still certainly be entitled to any accrued holiday during that period.
Hey, Caroline, absolutely brilliant. Somebody else is just typing there as well, as I can see.
Yeah, I saw that. Yeah, we'll see if any other questions pop up. Oh yeah, and I think you put up, Liz, having about the feedback. Yeah, we always like the feedback, don't we, Liz?
we do. It does help. Masses. Please leave your feedback. We really appreciate it.
Oh, so Lorraine's had, would the holiday entitlement continue to accrue during the notice period? Yes, it would, because they're still employed. So if they're also on notice and working for you, they're still employed. So that's why you can bring it to an end. You can terminate the employment earlier by paying them in lieu of notice. Often you need to check that your contracts allow for you to pay in lieu of notice. Because technically, if they don't allow you to do it, is technically treated as a breach of contract. But yes, whilst they're employed by you, even if they're on notice, they will still continue to accrue holiday. But you can ask them to take the holiday during that notice period. You can either specify that in your contract. You can either put something in your contract of employment, say you may be required to take holiday during your notice period. If you don't have something like that in your contract, you can still ask them to take holiday during their notice period by giving them the notice requirements under the working time regulations, which is basically double the length of the holiday that you want them to take. So if you want them to take 5 days holiday, you just have to give them 10 days notice that you want them to take 5 days holiday. So yeah, thanks, Lorraine.
Okay. Thank you. That's lots of good questions. I've put your contact details up there, Caroline, before we lose everybody.
Oh, thank you.
Sure that you'd welcome anyone wanting to get in touch directly with you.
Oh, of course, yes. Yeah, please do.
Brilliant, and I've put the link there because you can download the site here, but we will be putting this recording up on the LinkedIn company page. There's a link there that you can go and access it and share it with your friends. Really good stuff. Doesn't look like there's any more questions. Looks like we're getting a bit of a few people leaving us, so I'll just wrap up. If you want to join us on the 30th of March, please do so. Marie Walsh from Consilia Legal also will be talking about the National Living Wage and the law. And alternatively, you can join us next Wednesday morning at 8:30 to talk about neuroscience and achieving anything if you change your behaviour. So thank you, everybody, for all your questions and everything. Please join us again soon, and we will be in touch with everything that's happening.
Thank you very much, everybody. Thank you.